Good morning. Welcome to the Utah Court of Appeals. We have a number of cases on our calendar this morning, two of which are set for argument, and the first one on that calendar is Ragsdale versus Fishler. The case number is 2023-0023, and let me ask the attorneys to make their appearances for the record, please.
Karthik Nadison on behalf of appellant George Fishler.
Good morning.
And James Dunkelberger of the law firm of Bennett, Tuller, Johnson & Deere for the Abilene Cross Appeal.
Good morning to you as well. Thank you for being here today. We have a cross appeal, and I guess there's been some discussion with the clerks here about timings. I think we're going to go, as I understand it, 10, 13, 5, and 2. Okay, and if we're asking questions, obviously, we can, don't worry about the clock as long as there are questions pending. But if not, then, wrap up in 30 seconds or so, and we'll move on to the other side. So any questions about how we're going to proceed this morning?
No.
Okay, great. We look forward to hearing from you.
Occasionally, counsel need a reminder that on that rebuttal on the cross appeal for the 2 minutes, that's limited strictly to the cross appeal.
That's a good reminder. Thank you, Judge Orm. By the way, I'm Judge Ryan Harris. This is Judge Greg Orm and Judge John Luthi. That's the panel you have today, and we're excited to hear your argument.
Well, I hope that's a good thing when you say you're excited to hear our argument. If it may please the court, this case is about whether a nonviolent protest of the business next door turns into stalking if your protest is sufficiently offensive, the content of your protest is sufficiently offensive, and you persist in the same protest for an extended period of time. Now, in doing so, I think there's an important consideration that has to be made, which is there has to be a separation between a moral judgment about whether we think what Mr. Fishler's conduct was appropriate, how offensive we think it is, and the objective legal analysis of whether his conduct constitutes stalking and whether it should be prohibited without violating the First Amendment. Now, there's no dispute today that Mr. Fishler engaged in a course of conduct. I know that was an issue in the original appeal. It was an area of discussion during the district court proceedings, but today and in this appeal, there's no dispute about the course of conduct. And part of the reason why is because that definition is so broad. It encompasses almost all social interactions. I've appeared, I believe, before all of these judges more than once. If any of you found my oral arguments emotionally distressing, which I hope is not the case, I would have committed stalking. That's how broad the course of conduct is. So the limitations on that law are two. One is the objective circumstantial analysis, right? That is, whether a reasonable person in the alleged stalking victim's position would have a fear for their safety or would suffer emotional distress. That's the first sort of guardrail. The second is the scienter element. That is, do we know, or did the alleged stalker know or should have known whether he would have caused a fear of safety or emotional distress? Now there is obviously been a change in the law, because in the intervening period we had the Counterman v. Colorado case, which said that the negligent, the should have known scienter requirement is not constitutional. Instead, it has to be a recklessness mens rea. So the
Counterman wasn't cited in any of the briefing, and I know that's a pretty recent case. No 24J letter about that.
We didn't, because we don't think this case is about the scienter requirement. We think this case is about the objective analysis in the First Amendment. And I think the scienter requirement, I think that to a certain extent, it's not really clear from the findings in fact and conclusion of law, seems to claim that Mr. Fishler knew that his conduct would cause a reasonable person to fear for safety or suffer emotional distress. It's not really clear from the findings, at least to me, but we didn't want to bring that issue up because we thought the objective analysis and the First Amendment issue were sufficiently important
Okay, so your view of counterman is it really just speaks to this?
Oops, sorry, I
Speaks-
think I hit my microphone.
No worries. Your view of counterman is it speaks to the scienter requirement, which you don't think really is what's driving this case.
Right.
Okay.
But where I think counterman is important is this analysis, the reason why it imposes the scienter requirement. Because if you read counterman, the reason for that is because of the First Amendment. The court goes through analysis of how the stalking statute has a chilling effect on First Amendment speech. And therefore, it imposed the mens rea requirement, the recklessness requirement, in order to temper that chilling effect. And it goes through a balancing act. It says, by imposing this, more conduct that might be stalking is gonna come through. But at the same time, we think the First Amendment is important enough that we're willing to allow that to happen in order to make sure that people properly exercising their First Amendment rights are not curtailed from doing so by the stalking action because they fear prosecution. So that's where I think counterman fits in, is in the emphasis and the recognition that there is a First Amendment violation or a First Amendment effect, an interaction between the stalking statute and the First Amendment. So I did want to bring that to the court's attention because I think that's important when making that First Amendment analysis.
We're in a bit of an odd position where we're evaluating whether or not what was done on remand is consistent not with our prior opinion, but with the Supreme Court's prior opinion, but they saw fit to have us make that call, so it is what it is. Looking at footnote 40 in the Supreme Court's opinion, we have language to the effect that on remand, we suggest the district court considers the factors we listed in Baird. And it listed them as including but not limited to the cumulative effect of the respondent's repetitive conduct, petitioner's background, knowledge of and relationship with the respondent, and any history of abuse, and I suspect that does not need to be physical abuse, between the parties. It seemed to me that the court took that instruction to heart on remand, considered those factors, made findings about them following a 2-day trial, and I'm not sure that she missed the boat on that. It seems like those were taken into account in her coming to her conclusion that the conduct would be objectively exceedingly offensive to a normal person in Ms. Ragsdale's position.
And obviously we have a disagreement there, but what I'd like to do is first split that up because the Baird factors apply to both the conditions, right? There are two conditions. There's fear for safety and whether you'd suffer emotional distress. Well, let me just start with the fear for safety issue. So what a district court can't do is make a blanket statement. I think that's what Ragsdale, not in the footnote, but the substance of the original Ragsdale decision by the Utah Supreme Court was that, hey, you can't make a blanket statement. You've got to individualize this. You've got to look at every single factor, and our guidance for you is Baird. Now, the issue is you can't just cite to Baird. You can't say, I considered the Baird factors, and here's my conclusion. And the reason I say that is because in the original evidentiary trial, that's what the district court judge did. What she said was a reasonable person in Ms. Ragsdale's circumstances would not have feared for her safety or would not have suffered emotional distress. It made that blanket statement and it cited under her circumstances. And the Supreme Court said, no, that's not enough. You can't just make that blanket statement. You've got to actually get into it. Now, the difference here is that in the findings of fact and conclusion of law, the district court didn't get into it. It made findings of fact, certainly, about how long things had been going on. It made findings of fact about what their relationship was. But what it didn't do was analyze those. So it didn't say, okay, they have no relationship. Their only relationship is Ms. Ragsdale's business location is next door to Mr. Fishler, and she sees him every day or whenever she drives by, and he engages in his offensive conduct. Therefore, based on that, I think that a reasonable person would fear for their safety or not fear for the safety. Here's why. And that's what's missing, right, is that analysis of the factors and an explanation of why those factors lead to the conclusion that there's a fear for safety. Now,
What you've,
sorry, go ahead.
what you've just articulated to me sounds a lot like an issue with the adequacy of the findings, that the court hasn't explained itself sufficiently.
Well,
And that ordinarily needs to be separately, that argument would need to be separately preserved.
right, and I don't think it's a findings issue, right? It's a conclusion of law because the Baird analysis is a legal analysis. So the district court can make its findings, but once it makes its findings, it's got to do the Baird analysis, and that's a conclusion of law.
So we can take the findings, so far as you're concerned, we can take the findings as our starting point and then move to consider whether or not the conclusions of law are borne out by those findings.
Right. So the issue that we've raised is, number one, is there an interpretation, is that interpretation a proper application of the stalking statute, right, under the Ragsdale decision? And the second is, are the findings of fact adequate, right? Because if the question is, you have to take all the circumstances into consideration, did the court do that? Now, a court obviously doesn't have to make a finding of fact on every single issue.
I thought you just agreed with Judge Luthi that this wasn't about the adequacy of the findings of fact.
No, it isn't. And that's why I'm saying, when we're talking about adequacy of findings, what I'm referring to is, are the findings of fact adequately supported by the evidence? And that's what I'm referring to. I'm not sure if I'm.
That sounds like a sufficiency claim as opposed to an adequacy claim, I think, is the nomenclature that we use. I think that's what you were
Yeah.
getting at, right?
Okay.
Anyway, I think we're probably saying the same thing, just kind of using different words.
Gotcha. Okay. Because,
But-
yeah, because
and I guess
I'm.
the follow-up
Yeah.
question for me then is, if we have, if the findings are adequate, that there's enough facts there to do the analysis, and then if the analysis is a legal question that we're reviewing de novo, and I think this may be what Judge Orm was getting at, can't we just, at this point, jump in with the findings that we've been given and do our own Baird analysis and see, do they support an ultimate finding that, yes, someone would fear for their safety, or yes, someone would suffer emotional distress?
I think that the court could do its own Baird analysis. I think that's been done before. I think that's what the court would normally do, is do a de novo Baird analysis based on the findings of fact. And so if the court said, listen, we're gonna ignore what the district court did. We're gonna conduct our own Baird analysis. I think it could. I think the court would have to reach, one of three conclusions, right? The first is that there are inadequate findings of fact. We can't make the Baird analysis. And that's for the court to decide. Number two is it can say, we did the Baird analysis, we disagree with the district court, there is a reasonable person wouldn't fear for their safety. Or it could say we agree. But I think that you are correct, that the court could make its own Baird analysis. It doesn't have to send it back to the district court because it's not a finding of fact, it's a conclusion of law.
And so I guess the point of those two questions was, it seems like you were arguing that the district court didn't say enough about how it got to its ultimate conclusion, but I'm not sure that we need to worry about that. And that what we need to worry about is the ultimate conclusion, not whether it's said enough about it.
I think that's correct. If the court decides to proceed that way, it certainly could. It could say, listen, we're not gonna spend our time analyzing what the district court says. We're gonna go ahead and we're gonna make our
Do
own.
a de novo.
Yeah, do a novo review. I think the court could do that.
Let me focus your attention on paragraph 14 in the findings of fact and conclusions of law. The judge begins with, respondent argues that there is no objective evidence that a reasonable person would have feared for their safety. That's paragraph 13. Paragraph 14, the court disagrees. And then there is a rather lengthy discussion at paragraph 14 before some further discussion in paragraph 15 that begins with further. And as I read that paragraph 14 discussion, 10-year campaign of harassment, cumulative effect of respondents' conduct. I'm reading the whole thing, obviously, but skimming a bit. most reasonable people would view respondent's conduct as nearly, if not entirely, unhinged, and could quite possibly conclude that it is unpredictable what respondent is capable of doing. And she italicized any reasonable person to be afraid for his or her safety. So, tell me what's wrong with that degree of analysis, having made the finding that the court did. What's wrong with that assessment in coming to the ultimate conclusion that this is conduct that would cause fear in any objectively reasonable person?
Okay. And let me take a step back. I'm going to answer the question. So
Okay.
I'm not trying to avoid the question. But let me take a step back and say that the Baird factors were adopted in order to make this an objective analysis, right? To avoid a district court making a subjective sort of blanket statements about here's the world, here's how I feel. I kind of feel that if I was in that position, I wouldn't like it. So the Baird analysis is supposed to focus that to get consistency and objectivity. Now, the problem with this analysis is that the court makes a blanket statement. She characterizes Mr. Fishler's conduct as a 10-year campaign of harassment. Now, in a certain sense, that doesn't matter. How she characterizes it doesn't matter to the Baird analysis. The Baird analysis is looking at certain factors. The 100 interactions says, okay, there were lots of interactions, but it doesn't look at the cumulative effect. And then your conduct is causing another person to be afraid. That's referring to the 2017 evidentiary hearing, right? Where Ms. Ragsdale said, well, I'm scared. The judge found at that hearing that a reasonable person wouldn't be scared. And Mr. Fishler testified, I'm not trying to attack anyone. I'm not trying to do anyone, to threaten anyone's safety. Instead, what I'm doing is protesting the business next door. So that sentence doesn't really address the Baird factors. So then we go to the next sentence. And it says, the cumulative effect is particularly fear-inducing because, given that it demonstrates obsessive and unreasonable behavior on respondent's part. So then the question becomes, well, how did the court decide that his behavior was obsessive and unreasonable, right? Because we have plenty of examples of protests where people stand in front of abortion clinics and call the nurses and staff baby killers, and worse things. We have people animal rights activists standing outside of farms doing the same thing.
It seems like those cases, though, are First Amendment cases, not stalking cases.
Well,
That we don't have cases saying, no, it wouldn't cause a reasonable person in the funeral attendee's position to not feel emotional distress. That there was no stalking injunction involved. It seems like what you're really getting at is the First Amendment issue there.
That is and it isn't. So what I'd say is those cases are not yet stalking cases. But in Utah, that's going to depend on how this court views this case, right? Because if the court views it in a certain way, then yes, those do become stalking cases because the very next thing that abortion clinic or farm or wherever is going to do is going to be file a stalking injunction.
Well,
And that question, though, whether it's a stalking case is a factual finding reviewed for clear error. Isn't that correct? That whether this would cause, whether the facts as found would cause a reasonable person in the petitioner's position to feel emotional distress is a factual finding reviewed for clear error.
No, that's where I disagree. Because when we were talking about the Baird factors, we were talking about how that's a legal analysis. And the Baird factors, the conclusion of that legal analysis is a legal conclusion that a reasonable person would fear for their safety. It's not a factual conclusion, and because if it was a factual conclusion, Baird would be irrelevant.
I see what
Does
you're
that make sense?
well, and let me jump in here too. As I understand this case, we have two separate questions. We have a statutory question and we have a constitutional question. And I think Judge Luthy was trying to get at, are you conflating those two in the answer to Judge Orm's question? The first question is, did the district court correctly determine that the stalking statute was violated? If not, you win, right? We don't even have to get to the constitutional question, right?
Correct.
But if yes, if the district court correctly determined that this conduct does constitute stalking under our statute, then we have to engage in a second inquiry to determine if there are First Amendment implications there and how deep they go, right?
Correct.
And I think Judge Orm's question went at the statutory part of this. This part of the district court's ruling is talking about
The
whether the statute is violated or not. And
And-
so
and-
the response to that question can't be, well, the district court's statutory analysis is wrong because it violated the First Amendment.
And I didn't mean to say that it did. When I was answering Judge Orm, what I was saying was, the district court reached a conclusion that his behavior was unreasonable and obsessive. And the question is, how did she reach that conclusion? What was it that she made it find that he was obsessive, or that his conduct was unreasonable? To me, that seems like a subjective judgment, right? That it was unreasonable and objective, because she's not citing to Baird, the Baird factors. She's not citing to anything on how she reached that conclusion, that it was unreasonable and obsessive. And then she makes another, and so that's just the sort of the jumping out point, because then she says, he hasn't yet physically threatened or assaulted anyone, but that doesn't make a difference. But I think under Baird it does, right? Because we're talking about the history of the party's abuse. So yes, it does make a difference what the person says, whether he's threatened to assault you, whether he's engaged in violent conduct, whether he's confronted you. I think that's an important consideration. I don't think the court can just say, well, it doesn't matter because he's unreasonable and obsessive. And then the court comes to this reasoning, which I think ends up being a blanket conclusion, which is saying people would think that he's not entirely unhinged, which as far as I know is not a scientific sort of statement. To me, it seems what she's saying is that he's crazy. I mean, I don't think there's any legal definition or scientific definition or medical terminology about what it means to be not entirely unhinged. But the general impression is he's crazy. And then it says, because he's crazy, he's unpredictable. And because he's unpredictable, he may engage in violence, so therefore he's a threat to safety. And that's the part where I think we really get into those blanket conclusions and just jumping from subjective conclusion to subjective conclusion. Because how do you go from, okay, his conduct is unreasonable and obsessive, so therefore he's crazy, therefore he's unpredictable, therefore he's dangerous. But under that view, any person who has a mental illness is a threat to safety. Anyone who's unpredictable, threat to safety.
I know you're out of time, but I have at least one more question. I'm moving over to the First Amendment analysis.
Please.
Maybe you can help me out here, and maybe it's just that I don't understand the proper First Amendment decision tree under SCOTUS case law, and maybe you can help me out here. But it's unclear to me from the briefing why we even need to engage in this question of whether we should categorize Mr. Fishler's conduct and speech as political speech or not political speech, right? It seems like, as I understand the decision tree, what we need to be focused on is whether it's content-based or content-neutral. And as we learned from the Reed versus Gilbert case, that inquiry encompasses both political speech and non-political speech. In other words, I need some help in understanding why it matters to the analysis that we engage with the question of whether this is political speech or not political speech.
Right. I think, and that was actually a question I was sitting and thinking about at length yesterday. So I'm super glad you asked it.
Mind melding, okay.
So here's how I look at it. Okay, we have conduct, a course of conduct. And I think the first thing the court has to do is saying, is that course of conduct communicative, right? Are there elements of speech in that course of conduct? And then it has to make the decision of, is the conduct entirely speech, or is it a combination of the two? And I think that's where that's the start of the analysis.
The conduct versus speech dichotomy.
Right. So because
That didn't
what
come out in your briefing,
No, it
frankly.
didn't, and that's unfortunate that I wasn't very clear about
Yeah,
that.
you guys started with the political versus
And
non-political
I'm going to get to that. I
Okay.
promise. I promise.
All
I'll
right.
get to it. So what happens is that if you have a mixture of conduct and speech, right, of non-speech conduct and speech conduct, the question then becomes, what is the nature of the speech conduct? If that speech conduct is political, then you still engage in the scrutiny analysis. Because the question the court has to ask is, when you start the branch of the tree the answer at the bottom is either intermediate scrutiny or strict scrutiny. And so the decision tree is to help you decide which one of those standards or analysis have to be applied. And so if we go down the side where we have a mixed conduct and mixed speech, the question is the speech political or is the speech non-political? Because if it's non-political speech and it's combined with conduct, the answer being, someone says, I'm going to, I hate you, and then engages in conduct, right? He sends dead rats to the person's house. That would go under the intermediate scrutiny side, because
And we can
speech is
decide that
important.
without engaging in the content-based or content-neutral inquiry?
Oh, no, you would, right? Because you have to, but
So how do these all
sometimes-
fit together? How do these
Right.
pieces all
And-
fit
and they-
together? That's unclear to me.
Right, and I think that, to be quite honest, it's not really clear to any of the courts that decided it, because they've kind of jumped around with the concepts, but the way I've reviewed it, and my sort of attempt to synthesize all of this together, is that there are cases where courts say, listen, we don't really care what your speech was, your conduct, right, your non-speech elements were sufficient to bring you within the ambit of the stalking statute. And there are other courts that have said, listen, you had non-speech elements there, but we feel that because your speech was political, it still falls within strict scrutiny instead of intermediate scrutiny.
But directing vulgarities at another person, that doesn't seem just like classic political speech.
But it is. It is classic political speech, because the Supreme Court has said, hey, listen, when you direct vulgarities, when you say, F you to the police, you're making a political speech. And so yes, it is a political speech, because what F you means, or at least means now in our society, right, is disapproval.
But what about your example? If I hate you, I'm going to send you rats. That was an example you gave of non-political speech.
Correct.
So,
Well, I guess it depends on who you're saying it to,
right,
perhaps,
fair enough.
right?
Well, and that seems like what Towner was addressing, that our Supreme Court has said that if your stalking injunction says you cannot say anything to this person or directed to this person, doesn't matter the content. You have crossed a line and you no longer can say anything to this person, that's a constitutional restriction, because the injunction in that case allowed the enjoined person to still say whatever they wanted about that person to anybody else. And if we're doing an as-applied analysis here, it seems like we have to look then at what specific conduct or speech is enjoined here. And I think that on that inquiry, the stalking injunction here is broader than the one in Towner.
It's very much broader. But here's the dichotomy, I think, that the court has to make, which is there is the question of, did you violate the stalking statute, right? That's a criminal statute that says, there's a civil, if it's proved by preponderance of the evidence, it's a civil injunction, right? There's an injunctive relief. But if it's proved by beyond a reasonable doubt, it's a misdemeanor. So the question has to be, first of all, are you guilty of stalking? And that's where the as-applied analysis and the facially constitutional analysis applies. Then there's a second analysis, which is, okay, we found you guilty of stalking. We're imposing an injunctive restriction, right? A prior restraint on your conduct. There's a second analysis at that point. The second analysis is this violating your free rights? Your free
Yeah,
speech
it
rights?
seems like if you're making a facially overbreadth challenge, you're challenging the statute itself, which does not look like that's what happened below. That it was an as-applied challenge attacking the injunction. As
No.
this statute has been applied to me through an injunction, I'm now challenging the injunction.
And see, I would disagree with you, because the constitutional attack was before an injunction had even been placed. The constitutional attack was, am I guilty of stalking? Can I be guilty of stalking under this statute if it violates my First Amendment right of free speech? So that's the issue. And so there's a second analysis afterwards, which is is the injunction comply with the First Amendment? But that's already, but by the time you get to the injunction, you found this person is guilty of stalking.
Isn't that because the issue, though, that the trial court seemed to identify below is that saying expressly, you've said that you're challenging this as applied to me, and not a facially overbreadth
Right.
challenge.
And I think the confusion here is what an as-applied versus a facially overbreadth challenge is, in a sense. And I think the court pointed that out, the district court pointed out that there's a confusion there. And here's the difference. So an as-applied challenge says the statute is unconstitutional when you apply it to my specific circumstances and say what I did was prohibited. The facial challenge says, hey, it doesn't matter what I did. What I did it might be constitutional to say I committed stalking, but the statute encompasses so much protected conduct that it itself is not constitutional. And that's actually an exception to the standing requirement that's normally imposed for challenging constitutionality. And that's separate from the issue of whether the consequence, the punishment from violating the statute is compliant with the First Amendment. So I hope
No, that makes sense. I'm just not sure that I've seen where the statute in the main, aside from any conduct or speech or whatever related to Mr. Fishler, that the argument was made just on the language of the statute alone.
So there was an as-applied argument, and that as-applied argument said the language of the statute, when applied to my circumstances, is unconstitutional. That was made in the lower court. The facial overbreadth argument was made on appeal based upon the district court's finding and facts of conclusions of law, where the court did not address Mr. Fishler's specific circumstances. It didn't address the applied challenge. Instead, what it did was it addressed it as a facial challenge. It said, listen, we think the entire stalking statute is constitutional. Therefore, Mr. Fishler, your stalking, finding you guilty of stalking does not violate the First Amendment. So that was where the facial challenge got brought in. It was not during argument in the lower court. It was in the finding and fact or conclusion of law where the district court said, hey, I don't see a difference. I'm just going to address it as a facial challenge rather than an as-applied challenge.
That doesn't seem consistent with her explanation of why she adjusted the personal conduct order. Do not stalk Ragsdale. This means you must not follow, threaten, annoy, harass, or cause distress to Ragsdale. The court concluded that in this modified form, the provision was content neutral because it does not draw any distinction based on any message conveyed by Fishler, and that it does not burden more speech than necessary to accomplish the goal of protecting Ragsdale from being stalked.
Right, but that's, again, after the court has found that it's constitutional to say that Mr. Fishler is guilty, right, has engaged in stalking. And now she's saying the remedy I've imposed is constitutional. So that's the distinction, because once you've committed stalking and you're guilty of stalking, you lose some of your rights. It's the same way that, when you're convicted of a crime, you lose certain rights, right, your liberty rights. And so part of the stalking analysis is the court says, hey, I think that applying the stalking statute, I think the stalking statute is constitutional. I think applying it to you, Mr. Fishler, is constitutional. Now I'm going to see whether the remedy, the punishment I've imposed, the sanction I've imposed is constitutional. And she says, well, the sanction is content neutral. So that's a different analysis from whether it's constitutional to say Mr. Fishler actually is guilty of stalking.
Okay, we've kept you over time.
I think that always happens, doesn't it?
Thank you for your patience with us. You'll have your full time on rebuttal. Thank you.
Thank you.
All right. Response.
May it please the court, the invitation before the court on this case by the appellant is to create from whole cloth a constitutional right to stalk. Put another way, an absolute defense against conduct that's long been held criminal, as long as there's a blanket claim or a colorable claim that It's a protest or political speech. And as Judge Mettler rightly pointed out, that simply cannot be the law. There's a lot to talk about from Mr. Fishler's counsel's comments. Going on with that theme and whether this is a facial challenge or an as-applied challenge, I think that distinction is not very important here. I made the argument below that because of the breadth of his ask about this constitutional argument that he was making, he was in essence mounting a facial challenge to the stalking statute, the sort of challenge that had been rejected in the Lopez case, but the sort of challenge that was successful in that Illinois case, Relaford, and the North Carolina case, Shackelford. You'll recall in those, they found facial overbreadth on similar arguments.
Your main line of defense, though, was that the overbreadth argument wasn't preserved below.
That's right, and it wasn't, for that very reason, because I said, that's a facial challenge, and he said, no, this is an as-applied challenge. And it turned out, probably doesn't matter practically for the resolution of this. Either way, the injunction is proper. Again, we'll follow Lopez as to the facial constitutionality, but certainly as applied, given the application of the Baird factors on both the threat of harm and the serious emotional distress, the correct standard was followed. Pages and paragraphs of analysis were given, and findings were made, findings that were not challenged in any sort of marshalling real sense here.
I have a question on the constitutional issue and the specific order given here, comparing it to the one in Towner. The first, and I know there are a couple of versions of the order, maybe I ought to confirm that I'm looking at the right one so we don't get on I'm looking at the one on page 928 of the record.
That's right.
That's the operative order, as I understand it.
Yes, Your Honor.
And the personal conduct order says, do not stalk the petitioner, but then it defines it that in a more narrow way, perhaps, than the statute defines stalking. This means you must not follow, threaten, annoy, harass, or cause distress to the petitioner. Maybe that doesn't narrow it much. The point that I want to make is, and ask, in Toner, our Supreme Court got everybody on the same page saying, we understand the injunction to mean you may not communicate to this person or direct communications to this person, whether they're political or otherwise. If that is the extent of the order, then it's constitutional. Because you can talk about the person to the whole rest of the world. That's the way I read Toner. Here, this conduct order is not that narrow, because it says you may not cause distress to the petitioner. And certainly talking about someone to everybody else may cause them distress. And so it's broader than the one that was constitutional in Toner. How is it still constitutional as applied here?
Yeah, and I think that's part of Mr. Fishler's argument as well. It's because that definition of stalk, so when you're talking about stalking, it's directed at somebody, whether directly or indirectly.
So you're asserting and or conceding that by using the word stalk, we're sweeping in that idea that we're only talking about communication that would cause distress because it was to or directed to the person, but you would concede that the respondent could talk about the home, Ms. Ragsdale, all of those things to other people, but not to her.
That's right, whether directly or indirectly. That is, an employee of Eva Carlston Academy, no. So long as, for example, if he was brought in on a violation of the order, it could be demonstrated that contact was in fact directed at Ms. Ragsdale indirectly through the employee.
Sure.
And that's kind of the issue that I have with Mr. Fishler's argument overall, is it completely discounts the role of findings of fact and conclusions by the district courts in the application of this statute. It sort of presumes that because we have this thing out there called political speech, or that, First Amendment certainly protects the speech that people make, that when you have a statute like this, if there's any way that that could be overbroad, the statute can't obtain. And it's just the opposite, right? In order to show facial overbreadth, you'd have to show that there's no scenario in which it would be lawful, or that it sweeps in a substantial amount of protected conduct.
For instance, Mr. Fishler could support a local political candidate, part of whose platform was to revoke the conditional use permit or whatever of the academy. He could go to the local planning commission and ask that conditional use permit or whatever authorization is in play, that be revoked for certain violations. Free to do all of that kind of thing and not offend to either the stalking statute or this particular order.
Yes, that's absolutely right. A violation of this order would require a demonstration that a communication was directed at Ms. Ragsdale. And in Mr. Fishler's kind of blanket, absolute First Amendment defense, there's no role for a district court to play in making that finding. So yes, there's no protection under his sort of version of these things, but obviously there would be a required showing, and for that reason, it not only meets the statute, but it's constitutional as well.
How does this, it seems to me at first blush that the court got it right then on the yard signs, at least in the front yard, that if the communication is from my own yard to a public street where more than Ms. Ragsdale and employees and clients of the home would be passing, that ought to not be enjoined as a blanket matter. Why can I not put a sign on my own yard that is going to speak to anyone that passes?
Sure. The point of disagreement there is, at trial, Mr. Fishler acknowledged that those were communications directed at Ms. Ragsdale. So if you look
But not just at Ms. Ragsdale, right? They're communicated to everybody who passes by, which is the category of people that would include her because she passes by there on a fairly regular basis, but it's to anyone, right?
No, he said specifically that they were located where they were so that they would not bother the neighbors, but they would be readily visible by Ms. Ragsdale and the others coming and going. So,
Given the way they were aligned or pointed.
yeah, and that is the finding that was made by the court, that those were communications. So in two places, the district court acknowledged that the signs were part of this course of conduct that was directed at Ms. Ragsdale. So if you go to R 913, paragraph 11, and R 921, paragraph 31, in both of those places, she lists, Judge Metler rightly lists the signs as part of the course of conduct, along with the flipping off and the shouting obscenities and so forth. And she did that on a specific finding, well, really, Mr. Fishler's own testimony, that they were specifically directed at Ms. Ragsdale. So absolutely, and I can understand her hesitance on the signs, because you think, oh my goodness, holding a sign, what gets closer to political speech than that? And maybe the signs in isolation as part of a course of conduct that would be, that somebody knows or should know would cause a reasonable person in Ms. Ragsdale's circumstances emotional distress or a threat, maybe that doesn't get there. But once you have the other attendant circumstances and a finding that there's been a course of conduct that constitutes stalking, you have to enjoin the signs as well.
How do you square that with the Westboro Baptist Church case?
Okay, so Westboro is, so really it comes down to the distinction between whether it's a content-based or whether it's a content-neutral communication. And that's the problem with the signs is, in reality, the signs are just another mode of communication. It doesn't matter what the signs say. If it does, I mean, deliver us from Eva sounds sounds broad. It sounds almost like you're making a political statement, but you can't go there with that without making the whole analysis content-based. Our statute requires it to be content neutral, just like the cases go to get to the scrutiny that we have meeting that substantial government interest of enjoining stalking. And so the Westboro Baptist case, as I understand it, is about whether something is political speech or not political speech. And here, Judge Harris, as you pointed out, the distinction doesn't matter. And Judge Metler says that. In fact, she gives this whole analysis of why it's not political speech under Snyder. And then at R 925, paragraph 39, she basically says, but I don't think it matters anyway because it's content neutral and it meets the scrutiny. The reason it was so emphasized, the reason it was briefed the way that it was because that Relaford case and the Shackelford case made a big deal about that, whether it's political speech or not. And in fact, some of those statutes from other jurisdictions write in a blanket exception to stalking.
I guess I'm still struggling with how these signs could be content neutral, right? We have to look at the content of the signs and apparently the intent behind the placing of the signs to figure out if they violate it. Doesn't that drive us to some sort of content analysis about whether they're, I guess as you put it, put there in a way that would be aimed at her as opposed to somebody else?
No, and when you try to do that, you fall into the content-based analysis that we're trying to avoid. Because again, it doesn't matter if the sign says, I love you, Christy, or if it says, deliver us from Eva. It's there, it's a communication directed at Ms. Ragsdale.
But it could be directed more broadly, and you'd have to inquire into his specific intent. See, and it seems like some of this may be contemplated by the concluding footnote of the court's order on page 928 of the record. By not enjoining the posting of any particular signage, the court does not intend to suggest that the posting of a sign cannot constitute stalking or that it is permitted by the injunction. That if you could come in and demonstrate that a particular sign is solely directed at, then you could establish it as to a particular sign, but to say that any sign you want to post now in your yard is prohibited would be an overbroad injunction, would it not?
No. Well, yes, but I don't think that's the ask here. The ask is to remove the two signs that are admittedly directed at Ms. Ragsdale as part of this course of conduct.
What if he moved the signs to a different point in the yard?
There's no way to undirect them at Ms. Ragsdale.
Well, I thought you said how we could tell that they were directed at her was where they were placed in the yard.
That's one of the facts that the district court used to find that they were directed at Ms. Ragsdale, along with Mr. Fishler's testimony, and Mr. Fishler did not challenge that finding.
Is there a sign still up in the backyard?
I'm not sure on that.
Did the injunction end up addressing that? It did not, did it?
No, I think that it addressed the signs as a package. I'm not sure if the sign in the backyard is still there.
I had the impression that the one in the backyard had come down.
I think that sounds right to me, but
Maybe it was just the QR code for the petition part of it that came down.
yeah. That one came down for sure. The fourth sign with the QR code came down for sure. I guess more broadly to your question is, that's why we're making a push for the signs here, because it was found at the district court below that they were directed at Ms. Ragsdale based on those facts that came out at trial. And so to get around that, you would have to challenge that finding. But with that finding, it becomes the same sort of content neutral prescription that the statute contemplates.
Now, maybe you'll think this is an unduly simplistic approach, but I found myself rather persuaded by Judge Metler's explanation that when she dealt with the other order, specifically concerning the signs, the proposed provision is content-based, quoting here now, because whether any particular sign would be prohibited by the injunction cannot be determined without reference to an evaluation of the content or subject matter of the sign, and therefore subject to strict scrutiny. Now, that explanation kind of rang true for me, but I guess it's also a little bit circular.
Because you can make the same argument with respect to flipping someone off, with respect to saying I love you, with respect to saying F you, with respect to saying anything, right? Well, it's only offensive, and that is actually the argument that Mr. Fishler's making. Well, it's only offensive because it's FU, right? If I started out by saying I love you, or in Counterman, the Colorado case, if I just had a bunch of posts that ranged from I love you, I want to marry me, to also why are you not talking to me and die, that you got to look at what those communications are actually before you can have a reference to whether or not it is stalking. But that is not what our statute permits, and that in fact is as far as I'm concerned, an impermissible analysis under our statute, because that is actually content-based.
Seems like the injunction, even as to flipping someone off, does not prohibit Mr. Fishler from standing in his front yard and just flying the bird. It only prohibits him from doing that as directed toward the petitioner and the other people named in the injunction. And so even in the instance of flipping someone off or mouthing words, you'd still have to come in and prove he didn't just do it in the middle of the night when no one was around.
Right.
And for the same reason, you can't just say, well, any sign in the yard is directed only at her. You'd have to come in on a case-by-case basis and demonstrate who's it directed at, and the court specifically allows for that in footnote 18 of the order.
Well, that's right, but then why doesn't it apply to the signs that she has already found were directed at? So for example, not to give Mr. Fishler any bright ideas here, but he takes out a billboard on I-15 and it says, I love you, Christy. Okay, we would come in to demonstrate that that's a violation of the injunction. It's clearly yes, it's a sign.
What if he put a billboard on I-15 that said "Deliver us from Ava"?
Yeah, good question.
That's why I'm asking it.
Well, I think it would, circumstantially, we would have to demonstrate that it's the same analysis. Is that directed at Christie? And it does not require any sort of content-based analysis of what the sign says in order for circumstantially it to be demonstrated that it was directed at Christie.
Well,
Well, you would want to look at the words and say if the billboard says, I love you, Christy, versus somebody needs to do something about Christy.
No, you wouldn't want to look at the words.
You would have to look at the words to determine if it was directed at her or if it was a political statement to the community that we ought to do away with these kinds of group homes.
You not only, you would not look at the actual content for that. That would be a content-based analysis. But you don't have to, because under Baird, we have all of these attendant circumstances that you look at that have nothing to do with what the sign actually says.
So
when did he put it up? Where did he put it up? Why does he say he put it up?
a lot of your argument today has been sort of centered around the words directed at.
Mhm.
And I guess I just want to ask you about the Supreme Court's decision in this case, where they were asked to construe the phrase directed at, and they indicated that that's not a subjective inquiry. Like, we don't look at that sign or that billboard and determine whether Mr. Fishler had an intent to direct that at Ms. Ragsdale.
Right.
We look to see whether that's statutorily prohibited conduct, and to look at that, don't we have to look at the content?
No. No, just like you don't have to look at the content of what he would say. So the sign is just
Okay,
another
but one of
mode
the-
of communication.
One of the categories that's statutorily prohibited is communications about somebody. Right? So don't we have to look at the content of the sign to see if it's a communication about somebody?
No. No, because you can get that from the attendant circumstances, or you don't get it.
Well, it seems like if someone had sent 10 letters to my address, whether that's stalking my wife or sending me a bill, I've got to open the letter and see what it says.
Okay.
And
So-
read and digest the content.
The content, that you'd never then have, well, the stalking would become very narrow because we wouldn't be able to consider what came out of the mouth of the person when they drove by each time and
Wow.
yelled out the window.
And I disagree with that in a limited way, just because the outside of the envelope before you even open it is addressed to you. And if it's not, then it's sent to your address. So the reason, to your question, Judge Harris, is that the Supreme Court weighed in on this is because, remember, Judge Bernard's Goodman in the first case said his subjective belief that it's directed at everybody in the business means that it's not directed to anybody specifically. And that was actually a blanket statement that the Supreme Court said, no, you've got to go back and you've got to actually look at it. And that was in response to a lot of this conduct occurring where just Mr. Fishler and Ms. Ragsdale were present in the street. Okay, so again, is that Mr. Fishler admitting, yes, I'm flipping Christie off? No, that is an inference that a finder of fact, like a district court judge, can use to make that directed at determination. So just like they could use something being postmarked from an address and reaching your address 10 times. They probably look to the historical context of this case to determine, is there a motivation for this person to be sending, Your Honor, 10 letters? You would not actually have to open the letters and read them in order to make that stalking determination. And as soon as you did, then it would be subject to strict scrutiny, which I don't think anybody is urging here. I'd love to just preserve on my last 2 minutes a word about the attorney's fees. I know we didn't quite get to it for the questions, but I'm not sure if that will be discussed in his 5 minutes, but I would love to at least put a plug in for the attorney's fees issue so that I could address it in my last 2 minutes.
Okay, fair enough.
Thank you.
All right, we have 5 minutes reply.
I have a couple of issues that I want to discuss, but I wanted to start with your example, Judge Luthi, because I thought it was a very striking example. And here's why. What if those bills are directed to you, right? They're addressed to you, they're for you. And those bills, I send 5 bills over the course of several months. And those bills, each one is progressively harsher, and they say, Judge Luthi, you haven't made your mortgage payment. And in fact, maybe you haven't. You haven't made your mortgage payment. And it goes on, and by the last bill, it says, we're gonna foreclose on your house. That's a course of conduct. Under Ragsdale, the original Supreme Court's decision, that's a course of conduct. It's a communication directed to you. That course of conduct reasonably gives you emotional distress. Your house is being foreclosed on. Now we've got to the crux of the problem with the stalking statute, right?
But the point that you're making now, if I understand it right, it is not the constitutional one, but the Baird analysis.
No. My problem is, I think under the Baird analysis, right, one of the new sort of additions to the Baird analysis was made by this court in 2021 in State v. Miller. And you said any threat to someone's reputation, livelihood, welfare could cause emotional distress. You're being told that you're going to be evicted from your house is going to be foreclosed on. You're naturally emotionally distressed. I think a court could reasonably find that a reasonable person in your circumstance would suffer emotional distress. So now we come to the problem, right, which is under the stalking statute, if we just apply it just by the words that are on there, I just committed, as your bill collector, as your mortgage servicer, I just committed stalking because I sent you more than one communication that would cause a reasonable person to suffer emotional distress. So where's the safety valve? And I certainly knew when I sent it that it was going to emotionally distress you. I think anyone being told their house is going to be foreclosed on would be emotionally distressed. So where's the safety valve? The safety valve is the First Amendment. So that's what I wanted to point out, is that you raised a problem that I think this court has to address, which is how do you protect people from statements, from communications that are totally legitimate, reasonable, necessary, but still cause a reasonable person to suffer emotional distress. And that's the point of Relaford and Shackelford, where they talk about people going to business planning meetings and saying the business shouldn't be there. Because in fact, to address the issue that you raised, Judge Orem, which was, hey, can he go to the planning commission meeting and say they should revoke their conditional use license? The answer is he can't, because that threatens Ms. Ragsdale's livelihood. She could, as a reasonable person who would be emotionally distressed, to know that Mr. Fishler is making communications about her, right, about her business, that could result in it being shut down. So that's where Relaford came in, and that is the sort of the heart of the First Amendment issue, which is all of these communications are now being encompassed in the stalking statute. And it's being used for a purpose that it wasn't intended to, right? Its intent was to prevent true threats. Intent was to prevent people from being, I think, as Lopez pointed out, of suffering severe emotional abuse. And that's why Lopez, in some ways, finding of constitutionality doesn't really affect this case, because in that case, it said, hey, it's constitutional because it's such a high level of emotional distress.
In the example that you just gave of going to the council meeting and arguing against the conditional use permit, if the concession were to stand that this injunction really only means communication directed to the individual, wouldn't that alleviate the concern of going to a council meeting and raising the concern? Because those communications are not directed to the individual. They are directed to someone else to make a policy change.
No, and here's why. Here's sort of the problem, because when we had the original Ragsdale case in front of the Supreme Court, that was sort of the issue, and the Supreme Court said no. And the order here, the conduct order, says don't commit stalking. And stalking, as we know, is any course of conduct, right, that involves talking to coworkers, right? Because that was why all of Mr. Fishler's conduct towards coworkers was brought into course of conduct, because the stalking.
Well, it kind of depends, doesn't it? Because if you're talking to coworkers to direct something at the person, that's one way to commit stalking. But under the statute, if I recall correctly, it's also communicating about someone can constitute
It says
stalking.
to or about, but that is one part of the statute. The other part says communications with someone's coworker. It doesn't have the conditions, and that was part of what the original appeal was about. Was, hey, he's communicating to a coworker. He's saying "F you." That's not about Ragsdale. He's not saying, hey.
But it could be indirectly directed towards Ragsdale.
Well, I guess, but we don't know, right? Because what he's saying is F you. He's not saying, hey, could you please tell Ragsdale I said F you to her? He's saying F you to that person. It's a general statement about Eva Carlson Academy. It's not about Ragsdale.
Well, at least that's a question that would have to be answered when you come in for an order to show cause or you get charged for violating.
No, it wouldn't. That's the issue, because the stalking statute says it doesn't matter. You're talking to her coworker. That's what the Supreme Court said. You're talking to her coworker. It falls within the ambit of the stalking statute, because the stalking statute doesn't talk about who the ultimate target, right? Because that was the issue. Who's the ultimate that Katie Bernard's Goodsman found, was that she looked at it the way you're looking at it, which is, hey, who's the ultimate target? Where is this going to?
Well, I guess this is why, to me, it's important whether we're doing analysis on a facially overbreadth challenge, because the statute does define stalking more broadly than I'm hearing the petitioner say, but we only understand the injunction to be more narrow than what the statute says. So if we're evaluating the statute for facial overbreadth, then I think we may, the points that you're making, I think are good ones, and we've got to consider them. If we're only looking at the as applied in terms of the injunction that ultimately issued, I'm hearing a concession that injunction is narrower than the statute.
Right, and there are two points I want to make. One is that the as-applied challenge is not limited to the injunction, to the relief that was granted.
Right, and we talked about that before.
Right, we did. And the second is, that's not what the statute says. So the petitioner, the petitioner can say, I interpret it however I want in order to make it constitutional. But what the actual order says is, don't commit stalking, which is reasonable, right? If I committed stalking, I think the court should say, don't commit stalking. But that course of conduct is so wide that personal conduct order covers it, right? It covers the sign. If my sign says, no Eva Carlson Academy, if Miss Ragsdale is emotionally distressed by the billboard I put up on the road because it attacks her livelihood, I committed stalking under the statute. and and I violated the no personal conduct order because it was a communication that was to her in the sense that she could see it. I knew it when I put up, that she drives down the freeway like everyone else, she can see it, and it emotionally distressed her. And I guess that's the point I keep on coming back to, which is that's a really problematic issue. And it's one that courts have looked at and said, well, we've got to put a limitation on here. Either we've got to limit what the emotional distress issue is, we've got to put an exception for the First Amendment, but something has to be done to curtail that broad spectrum of conduct that's being encompassed.
I know I'm taking time. I've got just kind of one last question on this, or observation, and get your response. I think that the initial inquiry of whether stalking has occurred does not look to what was said. There's no particular content. You can't say these things, but it's really focused on the effect that it has. Whatever it is that you said, if it amounts to a threat, or someone would, a reasonable person would feel that way, or gets emotional distress, now that's stalking. I don't see the content restriction there. But I think that then once you say, okay, because you did that, you can no longer talk to this, direct your communication at this person, then whether it's directed at that person or not, we may have to look at the content to figure that out. On the second step. Does that make sense?
Yes. So let me point this out to you. How do you determine the effect of a conduct on a reasonable person if my conduct is communication?
I think there's a difference between having to look at it and prohibit it, or saying what it could or could not be at the outset.
Well, but let me finish. So I'm looking at the content very carefully, right? Because whether Mr. Fishler is waving and saying good morning, and giving the finger and saying F you, are really important in determining whether the effect of the conduct, right? I mean, that's the only way I can determine it. So that's why I say it's not content neutral, it's content determinative, because you have to look at that content to find the effect.
And I guess my response to you, switching here, is that it's not prohibiting any particular content. It's neutral in that sense. It doesn't, sure, you've got to look at what the content is.
Sure.
But
It's prohibiting content, because what it's saying is you can, right? What it says is you can engage in certain content. So you can wave your hand and say good morning every morning, but you cannot give the finger and say F you every morning. So no, the statute by its very terms is saying it's prohibiting certain content. Now, obviously, there are content neutral applications of the statute, right? There's the Carson v. Barnes case where I point a gun at someone. Well, I think that's a conduct, that's not speech, it's nothing. There's no viewing of the content when I do that. But when we have a case like Fishler's, where we're just talking about the finger and the FU, then we are looking at content, because that's the only thing we can look at to determine it. So we're looking at the content and we're saying you cannot engage in content that results in this result, that makes a reasonable person fear for their safety or suffer emotional distress. But you can, right? It wouldn't be stalking if you waved good morning and you wave good morning every day. So yeah, I think the content has to be examined and is prohibited by the stalking statute, because that's the only way we can determine whether we get the effect or not. Does that make sense?
Yes, but I still disagree. For example, you can't yell fire in a crowded theater. You still have to look at the content, but the word fire isn't prohibited. That content is not prohibited. But you still have to look at the content to figure out if it can be prohibited.
But the fire case is one where the First Amendment doesn't apply, because what the Supreme Court has said in the fire case is, hey, your speech isn't protected. The content's still looked at, because obviously whether you say fire or whether you say I hate this movie is really important. But what the Supreme Court says is, because it's a threat to safety, right, you're inciting a panic, it's not protected by the First Amendment. So I think that it really does make a difference.
Thank you.
Okay, thank you.
The prosecutor.
It did. Go ahead, Mr. Dunkelberger.
Sure. I wanted to just clarify from Judge Luthy's question. I don't think that I was saying that the injunction as issued is narrower than the definition of
I'm
stalking.
gonna object to the extent that the reply is supposed to cover the issues on the cross
Yeah,
appeal.
Mr. Dunkelberger, you've got to limit your 2 minutes to the cross appeal issues.
Sure.
What I understand are the signs, which did come up in Mr. Nardison's response, but I don't think he said anything about the attorney's fees, so we don't need to hear about that. And then we don't want to hear from you anymore on the original part of the appeal.
Yeah, it relates to the signs.
Okay, go ahead.
Yeah, in the sense that of how broadly we're casting the injunction as issued, and I think that that's a really critical point. So for example, in Towner, I understood your question to be Towner seems, or stalking seems broader than Towner, because Towner said about. Okay, and what I said is, no, by incorporating the definition of stalking into this injunction, it's self-limiting. Okay,
But
because
you're saying
you
it's
have to.
self-limiting to the statute.
Yes, and the statute itself says directed at. And that's exactly what we were talking about with
But the
respect to
statute
the
also
signs.
talks about just talking about someone. So the statute is broader than the injunction in Towner.
Yes, but I think you've still got to, it's directed at directly or indirectly. So that's the difference. It's not about someone to third parties. It's
Well,
about
the-
someone to someone who's gonna then relay that, or you recklessly now, under counterman, you recklessly, I guess, disregard that that's going to reach
The
them, and so
con-
that
the
sign
con-
is met.
The conduct that the statute says one or two or more instances constitute a course of conduct are talking to a coworker, talking about the person. And neither of those say anything about directing it anywhere. And so that's why I do think the statute is broader, and that it makes a difference if you're saying, yes, we concede that the order is as broad as the statute.
Okay, and then with respect to the signs are just like any potential future violations. You don't need to, you can determine that it's a communication to someone in violation of the stalking injunction going forward without any resort whatsoever to the actual content of the communication. Because from the other factors, such as you and I are the only ones present, and I'm looking at you, okay, and I'm saying it to you. Doesn't matter what I'm saying. You can test this by what could be expressive conduct. If I, again, had something that I disagreed with this panel about, and every morning when you left your house, you saw me surveilling you from across the street, I'm not saying anything, okay? But my presence certainly could be construed as expressive, but it doesn't matter. The fact is, I'm there. That is part of a course of conduct, and you aren't resorting to what I'm actually saying because I'm not saying anything. I'm just there. And again, you know, do we infer then that it's threatening? Is it menacing? So on and so forth.
Probably more a bar complaint than a protective order.
Okay. Unless there's any other questions, I'll submit on that one.
Okay, thank you.
Thank
We
you.
appreciate the arguments today, and thank you for your patience with our questions that went over time. We appreciate the arguments. Well argued today. We'll take this.
One question, Your Honor. In preparing for this, I noticed there are several other cases that were cited in which other courts in other states have sort of addressed the same issue. I don't know if you want me to send a notice of supplemental
Well,
authority to the court.
What we want is not really the issue. The Rule 24J, I guess it is, covers that, and if you think what you have to say fits within that rule, you're welcome to apply that rule and give us a 24J letter.
Great, thank you.
Okay. Thank you. We'll take this matter under advisement, and we'll issue you a decision as soon as we're able to do so. Thank you. Do you need a break? Do you need a break? Okay, we'll take a couple-minute break, and we'll come back to hear the second case on the calendar this morning. Thank you.
All rise.